Aviv is a postdoctoral fellow at the Hauser Global Fellows Program at NYU School of Law. She is also with us at the Minerva Center for the Rule of Law Under Extreme Conditions. Her work focuses on international law, and she has a very impressive list of many publications, including in the American Journal of International Law, in the Columbia Journal of Transnational Law, Cornell International Law Journal, and more. Today, she will be speaking about promoting peace in international law, bringing states to the mediation table, a subject that, well, is sadly extremely relevant as we speak. Although maybe the definition of states is something that we can talk about later. But in any case, I'm very happy to have Shelly with us today. Thanks for giving this presentation. Over to you, Shelly.
Hi, thank you. So yes, my article deals relevantly enough with promoting peace in international law. Now, peace, as we all know, is the main purpose of modern international law. However, modern international law is somewhat more focused on the prevention of war, of armed conflict, than on the actual positive promotion of peace, and I will explain. So first of all, how does one describe, define, and measure peace? Well, peace is usually determined by a negative definition, the absence of armed conflict, the absence of war in older days. Even though there are some kind of definitions that are on positive language, such as cooperation between states and so on. Well, peace can be measured, is usually measured on two different scales, even though they do interlap. One of them is of warmth. Warm peace is such as the one we see among European states, close cooperation, free borders, and so on. Normal peace is what we see in South American states. It's not as close as the European peace, but there are normal relations between states. Oh, just a second. And cold peace, perhaps Israel and its neighbors who have peace agreements between them, is kind of a good example for a cold peace. There isn't an ongoing armed conflict, but the relations are not as close. There isn't a close cooperation on trade, security, and other dimensions. Another scale that can be used is that of stability, the proximity of armed conflict. So we can have stable peace, one where armed conflict is not something you take into account in your interstate relations. You can have kind of a normal or a kind of normal peace in which it's not like you cannot even imagine a scenario of armed conflict, but it's not something you take into account in the day-to-day account. And a very unstable peace in which armed conflict is always on the table, and you always kind of think about that option and that possibility, even if you're not the initiator of the use of force. But it's part of kind of the general atmosphere, the relations between the states. Now, research shows, and there is extensive research about peace and its stability, that when there is a continuous conflict among states, the thing that makes sure more than anything else that the conflict will not resurface again is the conclusion of peace agreements. Peace agreements that deal with the core issues over which those two states fought to begin with. And we're talking here about states because the reference and the kind of topic of this research is the UN Charter. And we'll discuss about this topic a bit longer. So when we have so examples for states that did not conclude kind of a peace agreement that deal with the core issues and the conflict keeps on resurfacing again is Israel and Syria, for example, 5 rounds of fighting, and who knows what the future entails. I hope that not more, but we can never know. India and Pakistan, the Koreas, China and Vietnam, and so on. One can even maybe mention the United States and Iran, even though I'm not quite sure if that's a good example. And the efforts that are made on the international level, on the legal international level, to make those states come and sit beside the table and talk and try to conclude a peace agreement is insufficient. Now, this is a very recognized fact in the field of international law and conflict resolution. The chapter in the United Nations that deals with conflict resolution is often referred to as the neglected stepchild of the charter. And we'll get back to it soon. And first we'll start with some history, and then we'll go back into the charter era. So in the in the past, war was the way of living, the way of gaining capital, more territory, collecting taxes, and so on. It doesn't mean that peace wasn't a value. It was more like an utopic value that you aspire to. It's mentioned in the Bible, but the way of living was the way of war. And it was a legitimate way to maintain your politics. Now, in the 15th century, with the rise of just war theory, peace did come as a more centric value, but it wasn't the leading value. Just war theory, as the name suggests, is concentrated about justice. So as soon as there was a just cause, peace was not considered something that should be taken into account in a serious way, and war was commenced. Now, the discussion is about just peace. In the moment that this peace is no longer just, then it's no longer real peace. So are saying the philosopher of just war theory. In the 19th century, there was a very interesting and elaborate net of treaties and agreements among European states. And it is described by scholars often as the peaceful 19th century. Now, indeed, inside Europe, there was a relative peace. European states did not fight along a lot with each other. However, you cannot call this century really peaceful, as European people engaged in a lot of violence just outside the borders of Europe, mainly in Africa. So you should take this peaceful European century kind of with a grain of salt. However, this ideal century within the boundaries of Europe was disturbed by World War I. In the aftermath of World War I, the League of Nations was established, and finally the value of peace was put by the drafters as the first and leading value. However, please feel free to use the raise hand. Oh, sorry. However, this kind of ideal did not last for long. As we all know, it got interrupted by World War II. I will not get into the reasons of World War II. Of course, it's not all due to the convention of the League of Nations Convention, even though some scholars give some examples of how it failed to maintain peace. Most of it is attributed to the peace agreements were unjust, who were forced upon Germany and kind of forced it into re-engaging with hostility. However, World War II broke out. We all know the devastating results. And at the aftermath of World War II, the world said never again. The UN was established, the UN Charter was drafted, and peace was once again, but here again more seriously so, it became the main and the leading value. So nowadays we can say, and most authors agree, that justice is no longer the leading value, but peace. And the realization was that in order to reduce violence and to refrain from another world war, we need to keep the world at peace, to keep the world stable, and watch that it remains secure. Now, this means, of course, we all know that there is a prohibition on the use of force between states, with the exceptions of self-defense and Security Council of authorization, of course. But also the complementary meaning is Chapter 6 of the UN Charter. Chapter 6 engages with the pacific resolution of conflicts between states. So it complements the prohibition of the use of force, because states cannot use force in order to resolve their conflicts, and they must solve their issues in a peaceful manner. Now, Chapter 6 is comprised in such a way. First of all, there is the states, Article 33, which lets the states resolve matters on their own. The article is very flexible. It has a list of conflict resolution methods that states can use. They have to approach each other, decide on a method of conflict resolution, and start in resolving the conflict by themselves upon their preferable means of conflict resolution. In case this doesn't work, there's another kind of process and a roadmap in which the Security Council mostly can give non-binding decisions and advice and kind of help the parties to resolve their conflicts. Now, the Security Council, which is the body that is in charge of this process, other than Article 33, has not mentioned those relevant articles in its decisions at all. Never. It has not been used. It has not referred to Articles 36, 37, 38, which kind of deal with its own authority to address to such conflicts. It simply ignored it altogether. One of the explanations to it is that Chapter 7 of the UN Nation Charter, which deals with binding forces of the Security Council, kind of overrides it. States reach out in the Security Council itself straight to Chapter 7 and kind of jump over Chapter 6. Now, when legal scholars analyze and look at this ridiculous situations in which Chapter 6 is not being put to use, the explanation that is most often given is that Security Council is paralyzed. It is a paralyzed body. The veto power is being put to much use. And even when it doesn't, it has a chilling effect on the overall operation and approach to the Security Council. And this is portrayed as the main obstacle of Chapter 6 from being successful and from living up to its potential. Now, what I'm offering in my article is another point of view. I think that looking at the problems of the Security Council is, of course, very much important, but it's pretty much useless because it's a much broader problem. The Security Council's paralysis concerns many other aspects in international law. It's not exclusive to the problems of Chapter 6, and it will not be solved on that kind of specific point only. However, Article 33, which is the beginning of this process, does not include the Security Council, and it concerns the ability of states to reach a solution by themselves. And I think that this is the first point that we need to examine and to look into in a critical manner. Now, when we look at Article 33, it's an article that surrounds pre-negotiations, talks about talks. States has to approach each other and decide and agree upon a matter of conflict resolution. There's a bucket list there with conflict resolutions methods such as negotiations, inquiry, mediations, conciliation, arbitration, international and regional tribunals, and so on. Now, I think that when you look on obstacles of states to start and initiate this process, we can talk about few relevant obstacles. First of all, states that have a history of animosity and of conflict do not trust each other. They will not easily do the first step of approaching to the other state, reaching out and saying, hey, let's start talking. They're scared that this might put them kind of in an inferior position for negotiations. Furthermore, the other state may not see such suggestion as being honest and genuine, because there is a lot of suspicious and animosity going on. And furthermore, as we all know, making peace is not always the popular thing to do at the home front. So leaders and leadership might be hesitant to offer such thing from fear that it will not be deemed popular at home and will hurt their position, their political position. So the main problem here is that the strength of this article, the flexibility, the fluidity of it, it's also its weakest point because it requires states to cooperate and to work together. And those are states that are lacking in those exact fields and then might find it very difficult to do. So what I'm suggesting here is that we have to think about making this process easier for states. So I do want to preserve their free choice, but I want the process to start automatically. I want to kind of leap over those first obstacles and let the process kind of roll itself into action. So what I'm offering here is a mechanism of defaults. Now, defaults have been proven very efficient for individuals for planning individuals' behavior. But they've also been proven much effective with states, Now, this does not mean that a state will fall into some legal trick and behave against its own interests and wills just because we put a default here and changed kind of the way in which the provision is built. But it does mean that it might make it easier for states to refrain from obstacles in case they do want to actually promote peace and engage in peace talks. So it's not a magic solution, but it might help make things a bit easier. So what I'm offering here is to pick one of the methods of conflict resolution that are already included in Chapter 30, in Article 33, and making them a default method. Now, this means that states still have their free choice. They can agree otherwise. They can agree not to talk. They can agree to choose another method. They have their free choice still. But in case that they did not change their preference, then the chosen method will start commencing on an automatic basis. So now when we're trying to decide which one of the methods will be the default method, there are a few criteria that has to be taken into account. First of all, there is the legitimacy of such method. We want the states to be able to accept it. We don't want them to have antagonism towards this method. That means that some element of autonomy of a choice has to be preserved. So I'm not taking into account methods such as international tribunals or arbitration in which a binding decision is given, because I don't think that states will take upon themselves a method of dispute resolution that will bind them and not give them some kind of discretion to accept or to decline the offered solution. Another criteria that has to be taken into account is the chances of success. We want to take and to pick a method of dispute resolution as a default method that is most likely to bring the states into a good solution that can stick over time, that can get them to conclude a peace agreement, which is the ultimate goal of this entire idea. And the third, which is the most problematic one, and I will say from beforehand, this one I've not tackled with it completely, is the one of the best chances of implementation. It's not easy to offer a change in the UN Charter, and for sure it's not very realistic, at least not right now. And some means are not easy to achieve by interpretation. So this is something that has to be thought about as well. But this kind of last criteria made me consider only the methods that are already included within the article. For example, there are other good methods such as good offices, which is not listed in Article 33, and I did not list it there because it will be harder to get there by means of interpretation, which is the less aggressive manner. So now, when we think about those methods that are listed in this charter and do not include a binding decision at the end, we have, first of all, negotiations. Negotiations is the most accessible, easy, cheap method of conflict resolution that is listed there. And it just requires representatives from both states and a room. That's all. The two parties sit there and talk. And who knows, maybe nowadays it can be done via Zoom. That's a possibility too. So the advantage, as I said, it's very accessible. It's very easy. However, there isn't a third party that kind of leads the way, that bridges the gap. Two states are on their own, and that might prove to be a bit difficult in the case of two states that have kind of deep entrenchment, that are hostile towards each other, and they might need a third party's guidance. Now, when we talk about inquiry and also conciliation, we'll talk about it later. Those are two methods that include kind of like a fact-finding mission, a report that settles between the controversial facts of both parties. Now, this can be a bit problematic too, because first of all, some of the conflicts are deeper than just disagreements about basic facts, and they include concerns for future kind of arrangements, security wars, and things that are past what happened back then. And also, I think that it might be problematic in the legitimacy department for a report to come out that kind of decides on the correct facts, because even if the conflict resolution method chosen at this time fails, such report may be the starting point for future negotiations and attempts, and it might be problematic for parties who don't exactly accept the kind of final report and the determinations there. So what I'm staying with here is negotiations and mediations. Now, mediation is like negotiations, but with the intervention of a third party that conducts the entire affair. Now, this third party can bridge between the opinions of the parties, can offer its own solution, can offer sticks and carrots in order to encourage and discourage certain behaviors. And I think that this is the most useful method in such cases. I think that a third party here may be beneficial in the sense that it can save face because the parties don't have to accept their adversary's proposition, but a third party's one. But also from a substantial level, they might trust better such a proposition coming from a third party and not from their enemy, so to speak. Furthermore, incentives here are important. A third party, if it's a strong one, an influential one, might offer even better incentives to get to a solution, a financial one, corporations, and so on, that might drive the parties towards a conclusion in a way that they would not have done otherwise. But now, of course, we need a good mediator. So in that scenario, we have to choose a mediator. And because every conflict is different and every conflict needs a different mediator, here too I suggest a default mediator so the parties can agree upon another one if the facts of the conflict and their desire suggests otherwise. Now, when we think about a good mediator, the legal scholarship should suggest it should be someone with experience, psychological skills, rhetoric skills, and power, because it has to suggest incentives and sticks, carrots and sticks. And also you think about being impartial, but surprisingly enough, legal scholarship suggests that such party doesn't have to be impartial, and it might even work in the benefit of the kind of the party that isn't part of the two closest parties. So for example, if we have two states and a third one is the mediator, the mediator might sometimes become more useful in pushing towards its own preferable solution and kind of giving incentives to the party it's not closer to, because it doesn't yet have such close relationship with, and actually offering more sticks and kind of intimidating over its ally, because it can take things away from them. So I'm not sure if that's the way to go, if you should actually actively go and find someone who is kind of not your ally, but legal scholarship suggests it's not a deal breaker, to say the least. Anyway, when I thought about who is best to be a default mediator, I've come to the conclusion that I think that the best option is, once again, as a default, it can be changed by the parties, the Secretary General. Because first of all, it does have this diplomatic role from within the UN Charter, Article 99, give the Secretary General diplomatic kind of abilities. It has done so in the past many times. Usually, it was mainly during the 80s, but even later on than that. It is perceived as somewhat impartial, and it has ties with a lot of states and international bodies and so on, and can be quite effective. So the idea here is that the Secretary General can be both facilitator and mediator. It can identify cases in which states are post-conflict and in need to get and conclude a peace agreement and are failing to do so by themselves. Send them a message, let's get together and talk. I'll serve as the mediator. You have this and that time to decide upon an alternative method of dispute resolution or upon an alternative mediator. But if not, come here and let's talk. And I think that this thing, clearly enough, if states are not interested in reaching into a peace agreement and in talking, they will just refuse. But it might make them easier if there are specific obstacles that kind of delay them from taking such an option. So it helps them to save face. The mediator does the first the first step. They don't have to approach their adversary. They don't have to be scared of doing the first step and kind of being on an inferior level in the position on the mediation. They don't have to be suspicious of this kind of initiation of dialogue, because it has not been done by their adversary. It's not a trick. It is done by the Secretary General, which does not have kind of a horse in the race. And most in all, they can always decide that they are interested in another method. So I think this is the best way from the perspective of legitimacy, of chances of success, and it is somewhat problematic from the implementation aspect. I'm not sure if it can be kind of put into the charter by means of interpretation. Maybe it can be done, but it will be quite aggressive. And the chances that the charter will be altered are not that high. But I do think that such seed and such idea is worth being planted, and to have it kind of out there, and maybe someday there will be something to do with it. Clearly enough, negotiations will be easier to kind of put into the charter, I guess, because it does not require an alternation of the entire roles within the charter. Now, an additional thing that needs to be done, and this is separate for the default notion, is that the Security Council has to be aware of this situation, and it has to start using this chapter, chapter 6. What does it mean? There are theories that the Security Council is using in practice the charter just without mentioning it in its decision. Some scholars have listed different decisions in which, even though those articles are not mentioned in, you can identify kind of the reason behind them. If this is indeed the case, then I think that it is important that the Security Council will start using the articles by their names to encourage states to use them, to bring more attention in the spotlight back into Chapter 6. Chapter 6 of the UN Charter should be perhaps the most important chapter of them all. If we're saying that peace is the main goal of international law, and the way to maintain stable and lasting peace is concluding peace agreements, then what is more important? The fact that it is being considered the neglected stepchild of the charter is sad, but it's also quite dangerous. It's a missed opportunity, really. So I hope that this entire kind of arena and chapter can be thought about again and maybe reconstructed with time in order to better suit the realities of conflicts that are not being concluded by a peace agreement and therefore tending to reoccur. Thank you all.
Thank you. That was fascinating. I had the fortune of reading the draft early on, and I told you then, and I continue to think so now, that this is a project that is really important because it focuses on the fundamental issue of modern international law, namely preserving peace, and diverts the attention from the obsession that now there is much literature about in terms of how to manage a humane war. So we have a lot of IHL scholarship that deals with questions of targeting, questions that we have heard about copiously in the media in the last few days. But we have not so much new scholarship that deals with this very, very important question. So I congratulate you for that. I have some comments of my own and thoughts of my own, but I would like to actually start off with Professor Gad Barzilai, who had indicated in the chat that he wants to ask a question early on in the discussion, and I will jump in later on in the conversation probably. And if anyone else has questions, please indicate in the chat or by using the raise hand function. Professor Barzilai.
Thanks very much, Shelly. It's a very genuine and brilliantly taken idea, which might be also very useful. I have two queries or two questions about it. One is, so when you were talking, I was thinking about three possible case studies, Israel and Iran. And actually, I think that your suggestion might be very useful in this context, because we are talking about two nation states. Then I was thinking about US and, as a case study, obviously, US and North Korea. So you have one nation state which is not a member of the UN and would be obviously very suspicious of the UN. And then I was thinking about Israel and Hamas, when again you have one player who is not a member of the UN, and again, for all the obvious issues, would be highly suspicious. So I was wondering about the feasibility. I mean, the idea is very genuine and very important. The question is, how do you evaluate its feasibility, namely the ability to translate it into mediation, conflict resolution, etc. My second question is about asymmetrical conflicts, because it seems to me that most violent conflicts nowadays would be about asymmetrical conflicts. So here you have at the table all the issues that you have mentioned of lack of confidence. You don't have really a cultural common denominator. Is it, so again, how you would suggest to apply it onto asymmetrical conflicts? But thanks very much. It's a wonderful lecture.
Thank you, Gad. So I will start with the last question, actually. One of the greatest advantages of mediation is that it's said to give equal power to unequal parties. So each side sits with the mediator and they're both equal, and their ideas can be represented on an equal manner. So it does empower the weaker party. And once again, as part of the solutions that the mediator can give, it can empower the weakest party. Now we have to remember that asymmetricity is the reality of international conflict. It's not illegal in any ways, it's just part of reality. But it can make it more difficult to reach a fair solution. So I do think that this type of solution that lets another party manage affairs kind of helps maybe to remedy some of the kind of downfalls of asymmetricity, because it can empower the weaker party. Now, regarding chances of success, this is undoubtedly the weak part of this suggestion, because first of all, it applies to members of the Charter, because it talks about the UN Charter and Chapter 6. Whether you can apply it to non-states where there is this possible, even though a bit far-fetched kind of interpretation, in which states that might have the aspiration of being as a state may participate as a state too. But let's say that the main road here is that of two states are both member parties. And I'm not sure how easily you can kind of use it and put it to use without actually amending the Charter. So right now, the actual chances of implementation are not very high, I would admit. But I hope that maybe in the future, international treaties are being amended with time. Sadly enough, usually after conflict. So maybe in the future. But I do think it's a good way of thinking if something like this comes up to the table.
Excellent. So I see that people are still kind of warming up, and I will take the opportunity to ask a question of my own, which in a way continues in the same direction, I believe. So you spoke a little bit in your presentation about dispute resolution as well under international law. And we know that under the existing rules, and especially the ICJ statute, Rule 36.2 allows states to, Article 36.2 allows states to already kind of accept jurisdiction a priori. So it is in a way a default rule. So we know that default rules do exist in public international law as it stands. And I think it's arguable to say that that default rule is not used that much, and there's there's a very common use of opting out of that. So I mean, you can opt in, but I mean, it's very easy to opt out, and I think it would probably be easy to opt out of the rules that you suggest. So I'm still not sure that I understand clearly enough 2 basic points about your argument. One is, so to bring states to even start with this, you say that there needs to be a third party, and you kind of discuss which third party that would be. I'm not clear on that. I still don't understand what is the power of the Secretary General or any third party that you might think of to bring states to do this. And second, in a way, I don't understand deeply enough, I think, how does this change the existing rules? Isn't there a way to see the existing rules as they stand, including Chapter 6, as already providing for all the mechanisms that you request? And if they're not used, it's not a problem with the rules. It's a different problem. And it could be a problem concerning politics, power, economics, technology, what have you. But to deal with it through the law would be perhaps inappropriate if the law already provides for everything that you are hoping for. So I may be misunderstanding, but I just want to get a little bit sharper on that. Thank you.
Of course. So, of course, defaults do exist in international law. The best way to look at Chapter 6 is as a roadmap. The ICJ is one of the kind of branches of this roadmap. The Security Council can refer to the ICJ a conflict. It has not done so, ever, under this chapter. So I think that the existing mechanisms are there, but they are not built in a way that makes it easy to use them. I think that this is the argument. I mean, the methods are listed there. You have bodies that are supposed to take charge and kind of lead the way. But the biggest criticism about this body is that the Security Council, due to its high politicization, think about P5 members, there's always someone who has kind of interest in the matter that will veto. And even if not, things are falling even before that because parties are afraid that one of the P5 members will veto the matter. So the fact is, the reality is that the way it's drafted now is not working. So you can say that it's all politics and we should kind of let it be. Or I think that another angle is to say, what can we do with the material that we have to build it in a more accessible manner that will help us overcome the existing obstacles. So I think that the main obstacle of this first article, the beginning of Chapter 6, is that, as you say, everything is already there, but there are a lot of pre-negotiation obstacles that prevent states from making the first step. Now, in this article, the Security Council is not part of the picture. No one is. It's just the states by themselves on their own that are supposed to do this kind of initiation and igniting the process and starting to talk. So I do think that the first thing that we need here is someone to help them do this first step. Now, research showed that once the parties sit and talk, and this can be with a mediator or without it, a lot of the kind of obstacles are being crossed. There is a tendency to kind of dehumanify the person of the adversary party, to think that they are not partners, that they don't care about their kids and their lives as much as the other party does. And when you read, did you see the Oslo Diaries? Which I recommend regardless. You come to see that when parties come and sit in the beginning, there is a lot of animosity, but in the end of the day, people are people, and they talk about their kids and about sports and about food and about whatever makes them human beings, and barriers are being broken. Now, it does not mean that you will start talking and forget about your country's interests, of course not. But it does mean that a little portion of the kind of high fences you've put before that concern kind of prejudged opinions that you have will fall apart, and things and research show that do start rolling more easily once you've actually come to put parties one in front of the others, of the other and talk. So the existing mechanisms are there. I'm just trying to find a good way to make them start, to give this first initial spark, and then to trust on the existing mechanisms to make their work or not. Of course, that's also a possibility. I'm not thinking it's like a magic solution. We'll have global peace in no time. Clear enough, that will not be the case. But it might help in those specific cases, using the already existing mechanisms that we have, just changing a bit the way they're built to make it easier.
Yeah, it's kind of nudging states to peace in a way, to use Cass Sunstein's term. Ido Rosenzweig, please.
Thanks, Shelly. Great presentation. I think I've heard an early version of it not so long ago, forum. When I listen to it and I think about the structure of the UN and how things usually work there, it seems that the nature of the UN or the DNA of the UN is to run away from getting yourself within the conflict. They've, as you said, Article 33 provides you just talk about talking or something like that. The entire Security Council is built on the ability of veto power, the ability to do nothing. And there is no one player, political player, that actually wants to be as a default within a conflict between two states or even states and a non-state actor. So I think what you're suggesting here is not just to provide a default, it's just to change the entire nature of the UN in a manner that would require not just a change in the charter to allow it to become a default, but to actually ask states to be more involved in the matters of other states, which I think kind of undermines the entire framework of the UN. So how do you see any player, including the Secretary General, the Security Council, and others, want to actually be involved, more active in that sense?
Okay, so first of all, I don't think it changes matters that much, because under Article 99 of the Charter, the Secretary General already has such capacity to engage in diplomatic affairs and matters, and it has done so in practice many times in the past. So Secretary General is both experienced and has the actual legal kind of even if not obligation, then authorization to do so. So I don't think it's that dramatical. And another aspect is that states are often very much into interfering with the matters of other states. Broking peace is something which has a lot of prestige into it, and they have a lot to gain. States do want to be involved in it. History shows to be the one that kind of made everything right. I did not choose a state to be the default mediator. If the parties to a conflict wish to kind of nominate a third party to take the place of the Secretary General, they can definitely do so if such state agrees, of course. So I think that the way it was built to begin with was not one that involves states into matters of other states, but the one to give someone who already has such capacity with more permission to do so freely. Instead of being asked to do it, just to initiate it by himself and start the process. And remember, states can just opt out. That's an option too.
Please, Stefan Oeter, Professor Stefan Oeter, I see is also wanting to ask a question. So maybe it's better if he asks the question. Professor.
Thanks, Itamar. I'm just a bit following up on the answer you gave to Ido's question, because I share your perspective that you're not so far away from the current system. And that's in a way my question, because in a way you have nicely reformulated the logic or described the logic of the existing system, where the UN Secretary General is in a kind of default position. It's technically mostly going through good offices, but kind of as soon as the Secretary General appoints a special representative, which then acts as a kind of de facto mediator in certain conflicts, it's not so different from the model you described. And that's in a way my question. what distinguishes what you propose from the existing state of the art, where the UN Secretary General, in a way, steps in by special representatives in most of the conflicts, not in all. If one of the P5 is involved, let's say Ukraine, Russia, it's a bit hopeless for this UN Secretary General to act there. But in most conflicts, he becomes active, he appoints a special representative, which de facto is acting as a mediator. And the advantage of that is it's difficult for states politically to say, no, I'm not speaking with the UN Secretary General. So he has a kind of default position. And in that sense, what distinguishes your proposal from the existing system?
Yeah, so that's a good point, and we'll explain. So Chapter 6 is, well, the Secretary General is mentioned there, but it's mostly within the powers and the management of the Security Council, which, as we said, does not do a lot with its powers under this chapter. Now, the Secretary General does have powers to act in such capacity under different provisions of the UN Charter, but it does not come to act under the very structured form of Chapter 6. So what I'm suggesting here, and like I'm saying, and I don't think it's a big revolution like Ido offered, I think it's actually very subtle. I'm just asking to kind of connect these two parts, to take the powers that it already had under Article 99 and to let it kind of slip into the process that Chapter 6 presents and let it begin, let it start. Now, what's happening now that everything is done kind of in a more casual manner? And like you said, it's a good option to use the Secretary General because it's not very easy to refuse to such person. But I think that if you take the capacity that it now does under such, maybe even voluntarily kind of looks into conflicts, it thinks that it has something to contribute to, but do it officially in a structured manner under the very kind of steps and levels that the chapter offers. I think maybe it's the way to give life back to this kind of dead letter of a chapter. One of the reasons that I chose the Secretary General is that I think that the proposition as it is requires some kind of an amendment or rethinking of the charter, which is not easy to kind of swallow. So using something that we already have inside and already does this kind of position in practice may be easier to accept. But yeah, I completely agree with your observation. Thank you.
No, and I completely agree. You're right that in a way, Chapter 6 is a misconstruction in describing the Security Council, the major role in instrumenting the kind of the toolbox of Chapter 6. I think the Security Council is structurally incapable of doing that. So it would have been better, but well, in 1944, 1945, the drafters had not a clear idea of what all this would mean in practice.
I'm sure.
Departing exactly from this 1945 moment, what would you... Are you able to share any thoughts in terms of what would you do to try to implement your proposals in today's world? Is that a possibility at all, or is this essentially?
So I'm not sure if it's possible. That's the very honest response that I have right now. I hope that at some point it will come to terms. One of the options that does not include actually altering and amending the charter is that of interpretation. If one of the bodies that are in charge of interpreting the charter and international law, if there's an ICJ decision that kind of includes such kind of interpretation, that gives kind of an authorization for this kind of way of thinking, maybe it can promote such idea. Maybe it will not be one for one to begin with. Maybe it will be something that just gives preference to a default, that does not specify which method is the default, but something that will, because think that you do have an obligation to discuss under Article 33. The obligation is already there. It's not an offer for states to solve their disputes specifically. It is an obligation under the charter. So the thing that you are changing here is to kind of make them fulfill their obligation on an automatic manner. So it's not such a great leap, but it does need one of the bodies that are in charge of the interpretation of the charter to make that first step and interpret it accordingly. I'm not sure. I'm not a psychic. I hope he does.
I think that earlier on, Professor Barzilai mentioned in passing our current conflict with Hamas. I don't know if this is fair, but do you have any thoughts in terms of how the proposal that you have maybe in some way, in some local, regional, limited way be implemented in order to help us move towards lesser violence in our own region? I don't know if this is fair, and you feel free to say no. I'm just...
clearly enough, this inspiration for me personally to write.
And I see that...
Eli. Do you want me to answer or to wait for Eli's question?
Actually, it's a follow-up question. I'm at the university as well, so I don't know if you can...
whatever you prefer. Eli can jump in.
Okay, I'll jump in, just to wrap up Stefan and Itamar's last points. And I think it will be very interesting to examine empirically what the special envoys of the UN General Secretary are actually doing. And actually the Gaza, or the envoy of the Secretary General to Israel-Palestine, is a good test case. And I don't know, it's also a question whether it's a personal perception of role or we see succession. So I think it will be interesting empirically to check whether the special envoy, and this connects also to the current round of violence between Hamas and Israel, is engaged at all in trying to mediate, or is only reporting to the Secretary General or to the Security Council on facts on the ground. And it will be interesting to examine whether different envoys saw their role differently. So I think it can be a very interesting empirical addition to the very interesting theoretical suggestions or reforms that you put forward.
Well, thank you, Eli. I do think it can be a very interesting follow-up article. That's a good idea. Thanks. And yeah, of course, the inspiration on a personal level to writing this article was frustration from our own situation and the fact that we're from one round of fighting to the other, and in between there's zero negotiation efforts. And we're not talking. The word peace is not in our day-to-day dialogue, not on a political level. And like I said, when I said peace is not always a popular thing to do, I discussed it with with friends from my master's degree that I remained in contact with, and they were astonished. What do you mean it's not a popular thing to do? And then it hit me that you don't always think about those aspects unless you're in this situation. Now, I don't completely know how this entire idea will affect our relationship with Gaza, but I do know that personally, I would really love for someone to just force us to sit together and talk, which is much, much better than the current situation in which no one talks. And every now and then we just use force to solve our problems or not to. So yeah, I don't have magical solutions for our situation with the Hamas, that's for sure. But I do know that talking is always better than not talking, and I have research to back it. So any kind of idea, plan, legal mechanism that brings both sides to the table, I think that is a preferable one. Than the one that when international law come and meets us every fighting round, kind of analyzing the way we fought, rather than thinking about how to actually bring peace. Sorry if that's naive, but that was really like the process of thinking that got me to actually sit down and write the article.
Can I say one thing?
Professor DEBORAH SHMUELI?
I was just thinking of there's a precedent with negotiations with the Taliban, US and the Taliban in 2014. It was called the Bergdahl negotiations.
Thank you.
Can you hear?
Yeah.
So where they negotiated for prisoner exchanges. So there are some interesting pieces on that in terms of negotiating with the enemy and asymmetric negotiations. I'll send you a couple of pieces on that, but there are certainly precedents to look at, not that far away.
Professor Gad Barzilai, Gad, can you rejoin?
Second. So first of all, Shelly, I think that one part of your paper that you may wish to amplify the symbolic part, because I asked you before about feasibility, but in fact, I think that your idea might be a part of symbolism in international diplomacy, which is very important. Namely, if people know that the UN does have in its maybe amended charter default system to bring about peace, it does have an important symbolism, which, I'm not sure how I would suggest to develop it, but might be a point that you would like to consider. And my second comment, I don't know if you are familiar with books by Saadia Tuval. He published two very important books in 1999 and 2001 about brokers in international diplomacy. One book was more theoretical, his classic book from 1999, and the other book was, if I recall well, about Yugoslavia. Because it might help you to develop your idea about brokers and how it might work in international diplomacy.
I apologize for my broken line first, and I want to give a great big round of thanks to Shelly for this presentation, this important research, and looking forward to follow up on further versions and iterations of this project and other projects as well. I think it was a really important, as I said, an important discussion to have among us at this time. Thank you so much.
Thank you all. Thank you, Itamar.
Thanks, Shelly.